One of the most important and macro external environmental element is political environment. Political environment with respect to business organization includes rules and regulations, laws, role of government in day-to-day business activities, etc. The businessmen need to pay attention to the political environment to see how government action will affect their business organization. Factors influencing political environment includes political stability, political relationship, that is central government and state government relationship, ideology of ruling government, tariff, that is import restriction on quality and quantity of goods, corruption level in the country, government intervention in the business. So let's discuss the role of government in business organization, regulatory role, promotional role, entrepreneurial role, and planning role. Regulatory role includes government intervention in business organization indirectly. For example, imposition of more import duty to control import. Promotional role includes measures to control and cover risk of export and import of goods and services. Capital intensive projects are machinery based and public sector undertakings are managed by central and state government. And planning role includes deciding time and usage of resources. And we already know there are three types of resources: financial resource, physical resource, and human resource. So these are the role of government in business organization. Branches of government includes legislative branch, who makes the law, executive branch, who administers and implements the law, judicial branch, who interprets the law. The role of legislative branch is lawmaking and policy making. It also gives approval to budget in the parliament. It includes legislators and members of houses of parliament. Executive branch, which interprets the law, it includes head of state, that is governor, head of government, prime minister and chief ministers, and cabinet. Next, judicial system, which includes judges of various laws and courts, such as magistrate court, high court, supreme court, etc. It is also responsible to settle the disputes that affect business organization, that is, disputes between employer and employees, between two employees, or between two companies. Next, legal environment. It includes laws and acts passed by the government. It also includes rules and regulations, court judgment, administrative orders related to business organization. It simplifies the legal aspect of business and provides smooth working of business organization. The businessman has to act according to these laws and their knowledge is necessary. For example, advertisement of alcoholic product is prohibited, and to give statutory warning on cigarette packets, to provide expiry date on packet items. So legal environment related to business in various rules and acts are business laws and corporate laws, employment related laws, competition law, health and safety laws, international treaties. Acts includes the Companies Act. Previously it was 1956, currently it is 2013. Industries Act 1951, Factories Act and Industrial Disputes Act, Consumer Protection Act. Previously it was 1986, currently it is 2019. Competition Act 2002 and Foreign Exchange Management Act 1999. Let's discuss Foreign Exchange Management Act 1999. Previously it was FERA 1973. Now it has been updated to FEMA 1999. FEMA applies in dealing with foreign exchange and security transactions. The main objective is facilitating external trades and payments, for promoting orderly development and maintenance of foreign market in India. It has indirect impact on export and import of currency. This act covers 7 chapters and 49 sections, but FERA was complex and non-specific. Distinguish between Foreign Exchange Regulation Act 1973 and Foreign Exchange Management Act 1999. There were complex provisions and there are only 49 sections with positive approach. It was strict in nature. It is liberal in nature. There were no penalty provisions. FEMA provides provisions for violating the law. It attracts monetary penalties, and if not paid, then there will be imprisonment. FERA deals with all transactions related to foreign exchange, whereas FEMA deals with only specific transactions related to foreign exchange. Section 2 of FEMA 1999 defines a person as an individual or Hindu undivided family, any company or a firm, that is partnership firm, artificial judicial person, association of person, body of individuals, whether registered or not. It also includes any agencies, offices or branches owned and controlled by such person. FEMA prohibits dealing in transfer of foreign exchange or foreign securities to any person other than authorized person. Transactions covered under FEMA. All transactions between residents and non-residents are covered under FEMA. It includes capital account transactions and current account transactions. Section 2 of FEMA Act defines capital account transaction as the transaction which alters the assets and liabilities, including contingent liabilities, outside India. Contingent liabilities are those liabilities which are payable or may not be payable depending upon the situation. So, a capital account transactions are those transactions which alters the assets and liabilities, including contingent liabilities, outside India of a person resident in India, or assets and liabilities in India of a person residing outside India. So, capital account includes assets and liabilities, while current account is defined as all transactions which are not capital transactions. It is inclusive definition. As per FEMA, all current account transactions are freely permitted. There are no rules and regulations required. except rule number 3, 4, and 5. Rule number 3 includes Schedule 1, which prohibits 8 items. Rule number 4 includes Schedule 2. There are 10 items that requires government approval. And rule number 5 includes Schedule 3. There are 13 items which require approval of RBI. Consumer Protection Act 2019. Previously it was 1986. It has now been changed to Consumer Protection Act 2019. This act covers consumer rights and redressal system. Consumer rights includes rights to consumer education, right to safety, right to seek redressal, right to information, right to be heard, and right to choose. Redressal system includes district forum, state commission, and national commission. The World Consumer Rights Day is celebrated on 15th March every year. Let's discuss what are the provisions that has been changed from the Consumer Protection Act 1986 to 2019. First point, regulator. There was no specific regulator in the act. Now CCPA to be formed, the Central Consumer Protection Authority. Second, precautionary jurisdiction. As we have discussed, there are three redressal systems: district forum, state commission, and national commission. So claim up to 20 lakh rupees can be settled at district forum. Claim from 20 lakh to 1 crore can be settled at state commission, and 1 crore and above can be settled at national commission. Now, as per Consumer Protection Act 2019, a claim up to 1 crore can be settled at district forum. Claim from 1 crore to 10 crore can be settled at state level, and claim above 10 crore is settled at national commission. Next, terrestrial jurisdiction, where a consumer can file the complaint. As per previous provision, a case could be filed where defendant resides or works for personal gain. So, at the place of defendant. But now, a case can be filed at place where complainant resides or works for personal gain. Next, compensation. Previously, there were no provisions for compensation. A consumer can approach to civil court but not to the consumer court. But now, a consumer can claim compensation for harm caused by product or services. Next, e-commerce sector. Previously, there were no provisions for e-commerce. Now, all rules of direct sales has been extended to e-commerce. Next, settlement. Previously, there were no provisions for outside court settlement. But now, court can refer settlement through mediation, that is face to face. And last, appeal to settlement commission. Previously, within 30 days, a complaint can be filed. Now, it has been extended to 45 days. Next, socio-cultural environment. It includes customs, traditions, values, and beliefs of society. What are the factors that affect socio-cultural environment? First point, nature and size of population growth rate, age composition, sex composition, family size and structure, level of income, and standard of living, level of education, it means literacy and illiteracy rate, consumer taste and preferences. The most important topic, corporate social responsibility. The business operates in the society. They get customers, suppliers, the raw material, everything from the society. So it is the responsibility of companies to contribute to the betterment of society. So the government has introduced the CSR rules in the year 2014 for the well-being of society. It works under Ministry of Corporate Affairs. The Companies Act 2013, Schedule 7, Section 135, Subsection 1 states that it is mandatory for all companies whose net profit is 5 crore rupees or more, or net worth is 500 crore rupees or more, or turnover is 1000 crore rupees or more. Here, turnover means net sales. So, as per provision, the company's net profit is 5 crore rupees or more, net worth of 500 crore rupees or more, or the turnover is 1000 crore rupees or more, will be liable for corporate social responsibility. This act, if once applicable, it is always been applicable. Even if the company's net profit falls below 5 crore rupees next financial year, the act applies to all Indian companies and all foreign companies whose subsidiary, holding company, offices or branches are available in India. The committee for CSR must include 3 or more directors, and at least one director should be independent director. Proportion contribution to the CSR. At least 2% of average net profit. Average net profit of preceding previous 3 financial year. India is the first country to bring the law incorporated under CSR. As we have discussed, it is applicable to all Indian companies and all foreign companies whose branches, offices, holding company, subsidiary companies are present in India. If the company has not spent in CSR, or in case of non-disclosure, or in the absence of details, the company will be penalized from rupees 50,000 to 25 lakh, or imprisonment up to 3 years.